I've been with Cornell for about 3 years. Prior to that, I spent about 10 years doing consulting for and taxes and financial services, actually for Farm Credit. And I'll be with Cornell for about 3 more days, and then I'll be going out on my own, doing the same thing privately. So I'm talking to you guys today about dealing with the non-farm family members, right? So the siblings or family members or potential heirs that are not necessarily interested in being on the farm in an operating capacity, but you still like them and would like to do something for them. So when we talk about these non-farm family members, right, and we talk about this issue of how do we manage them in terms of our big picture estate and succession planning, we have a couple questions, right? What effect does the planning that we do have on our business and the business's cash flow? What effect does it have on the operations of the business and the management, and who gets to make decisions, and how does the business continue to operate? What effect does it have on the ability to transfer or liquidate the business for those, either it could be your children or even non-family members that you've brought in who are operating the business? And what effect does it have, and this is the most important one, and I'm so glad that Chris touched on it, what effect does it have on the future family relationships? So those are kind of some of the concerns we're going to address as we talk through this. So the first thing that we want to look at, as you said, is the family and business goals, right? And that's so important that we start this process by addressing what is important to everyone and what does everybody want to accomplish. And as the business, moves through these generations, it becomes more and more likely that not everybody is going to want to be involved in the business on the farm, and that's okay, right? However, the parents generally still want to include them in the planning in some way, which is also great because we do still like them, but the concern is most of the family wealth is usually tied up in farm or business assets. So how do we balance those two things, right? How do we get value to those non-farm heirs without bankrupting the business and its ability to keep moving forward? Okay. And so when we're talking to you guys, we'll call it the senior generation, what is your priority? Is it perpetuation of the business? Is it just preservation of family wealth? Or is it a balance somewhere in the middle? So we start with trying to figure out what the heck are business and personal assets. And as you all know, when you're in a farm business, it becomes very difficult to separate those two things, right? They tend to be blended together. So the business assets, the farm assets, those are the hard assets, the things that the business owns, right? The cows, the equipment, the buildings, inventories. They might even have ownership in other entities. Maybe it's in land. It depends how it's structured, right? It is a business asset, but maybe some of you might have your land owned separately from the business. Some of you might have your land owned in your personal name and have the operations of the business in one entity, or you might have your land owned in another LLC and the operations separately. Your personal assets, okay? So that's what the business itself owns. Your personal assets for you as an individual include all of your personal stuff and the value of your ownership in that business. So if you're in partnership with someone else, your personal asset is the value of your half or your third or your share of that business. So it's really important to keep that in mind as we're talking about what it is that you're passing on or what it is that you're dealing with in your transition planning. Okay. So when we look at what you have to try to take care of all these kids, we have the easy stuff, right? We have these personal assets. Outside cash, that's the easiest one, right? Because you don't have to milk cash. It's the easiest one to deal with, and if you've done a good job of accumulating cash outside of the business throughout the operations of your business, throughout your lifetime, you've saved, you've taken, made personal investments, it makes it very easy, and it's never easy, but it makes it much simpler to have something to use to pass wealth to those off-farm or outside heirs without having to disrupt the assets that are in the business. Now, however, as farmers, we tend to plow everything we have back into the business, right? Traditionally have not done a great job of taking wealth outside of the business. And, well, yes, you've got that cash there at the time of transition. It did affect the farm cash flow to accumulate that cash over time, right? You had to be disciplined enough to take money out of the business and set it aside. The other really nice thing about cash when we talk about all of this transition planning, right, and when we talk about succession planning, we tend to kind of go down the path of doom and gloom, and we're always kind of talking about like at death. Well, gosh, what if you want to enjoy it with your kids while they're alive, right? Cash is nice because it's available now or later, right? And if you'd like to do something for your kids during your lifetime and help perpetuate your family wealth during your lifetime, you have cash now, and there's no rules about when you get to use it or give it to them. Okay? Life insurance is also a very powerful tool for planning for those off-farm kids. Right? Is there any life insurance salesmen in the room? Okay, so I won't pick on them. But what is the right amount of life insurance to have? That depends. But it is relatively easy to manage. The effect on business cash flow is just the premiums, right? But generally, you don't get a ton of benefit from it until you pass away. So there's limitations on that. And then you've got the outside non-cash assets. So what is that, right? Stuff that you own that's outside of the business, and it could be, maybe it's a camp or a vacation home, maybe it's a personal collection, maybe it's some nice old cars or a Harley, right? Those assets they certainly have value. Sometimes they're hard to liquidate, right? And sometimes they're things that you don't necessarily, there's an emotional attachment to them. So yes, there's value on paper. You say, okay, well, I'm giving you some farm stuff and I'm giving you this stuff over here, but how easy is it for them to liquidate them? And that's something to keep in mind when you're thinking about what it is that you're passing on. And then things start to get more complicated when we look at other personal assets like outside business ownership. So what could that be, right? So maybe you own some rental houses, or you have another business that isn't involved in the farm. And again, now you've left them something of value, but you've also left them a project because they have to manage it in order to get any value out of it. It's something that they have to actively manage. Because one of the questions you want to ask yourself is how much effort do you want them to have to put in terms of getting value out of these assets? Now we're getting closer to the farm. Now we have the farm-related assets, and usually that is the land or the land-holding entity. That does start to require some level of management. But the real key to this, and I'm going to let Steve get farther into the legal definitions of how these assets are owned and what potential pitfalls there could be if they're not done correctly. But the real question is, how is that land owned? Do you own it individually? Is it in an LLC, or hopefully it's not in a corporation, or in some type of business entity structure, or has it been moved into a trust structure of some sort? So it's really important to understand how it's owned, whose name is on it, and what that means in terms of your ability to liquidate it or pass it on to the next generation. So for the people who are operating operating the farm, whether it is your other kids who are still there operating, or you've brought in non-family partners, or maybe a non-family operator at this point. Chris mentioned, sometimes you don't have any kids that are interested in keeping things moving on, and that's fine, and you find somebody else to bring in and mentor and move along. But you have to remember that it's very important to them that they have the security that they're going to be able to use that land. Right? And so maybe you want to use it to pass value to these other kids. So how are they guaranteed that they have access to this land to run their operations on? And that's why it's really important to have good lease agreements. And that's another thing I'll task Steve with talking about. And then you have the actual operating assets of the farm, the actual farm ownership. Okay. And then we look at, okay, how is this owned? And this obviously requires the highest level of management. It's difficult to liquidate. You have to work hard to get the money out of it, right? You have to milk it or you have to plant it. It has the highest risk of any of the other assets that we've talked about, but it also has a high potential for return. So when we look at what you're leaving to a next generation, and you'll hear this probably from everybody you ever talk to, equal is not necessarily equitable. Right? And just because there may be on paper there's this high value in the farmland and the farm assets, and over here in the cash value, whether it's cash or life insurance, maybe that value is quite a bit lower, but boy, there's a lot of value to being able to just take it and stick it in a bank account and go on vacation with it, right? Versus having to get up and milk it every day. I always kind of walk through this series of questions when I'm working with the senior generation and talking about how we might want to structure this potential plan. My first question is, do you want your non-farm heirs to benefit from the farm business, not from your personal assets? Now we're just looking at the farm business assets. Do you want them to get a benefit from the farm business? And if so, when? During your lifetime or upon your death? During the business's lifetime? Okay, and those are two different things. Or only if the business is liquidated. And that's going to have a lot of effect on what direction we go with our planning. The next question is, do you want them to have to actively manage an asset? And what do I mean by that? Right? Do you want them to have to actually farm something or work something or manage a business? Or do you just want them to receive a dividend? You just want them to get a check? And do you want that return to be guaranteed all the time? They're just constantly going to get whatever that value is? Or do you want it to be dependent on how that asset performs, right? How well the farm does. So we look at the first question, do you want those non-farm heirs to benefit from the farm business? The answer is no. Now we look back at those personal assets and we go back through life insurance, outside cash, all those other things. And here's where that communication is so key, about communicating value and understanding that, yes, okay, your brother's getting the $3 million farm, and you're getting $500,000 in cash, but there is an intrinsic difference in the value that you're getting, so that you don't get all that finger pointing. Okay? But if the answer is yes, then we got more questions. Okay? So we say, do you want to get value to them during the life of the business? So if the business is still operating, do you want those non-farm kids to be getting something from it? Or do we say, no, they're not here operating it. We only want them to get value if the other kids decide they don't want to farm anymore, or the people that we've passed it on to, they decide they don't want to farm anymore. Well, in that case, we want some value to come back to all of the siblings. Does that make sense? And so we say, okay, only if it ceases to operate, right? We want the people who are there farming to have full use of those assets and get all the full value out of those assets as long as they're going to farm. But if they choose not to farm anymore, we want to bring that value back to the siblings. And there's a couple ways to do it, okay? One is you can just give them you can give them some ownership interest in that farm, but you make it limited, right? So they can't sell it, they don't have voting rights, they can't affect the operations of that business, they just own a chunk of the equity, okay? And it allows the business to just keep on rolling along using that capital without disrupting the cash flow of the business itself. And we're not going to get into all the potential income tax stuff, but it is really, really important that you work with a good person who does. The only thing it doesn't do is give a ton of protection to that non-farm heir, right? So what happens if the other kids run it into the ground? What if they, you said you had a hole digger. What if your other kids are hole diggers and they squander all the value of that farm? Well, now there's nothing left to split among the other kids, okay? So basically what would happen in this scenario, they own a piece of it, it stays there, the farm ceases to operate, everything gets sold, they get their proportionate share of whatever's left over. If there's nothing left over, they don't get anything. The other, and I'm not going to say the other, keep in mind, there are dozens and dozens and dozens of ways to approach this. I'm just kind of giving you some general outlines. But another way to manage this is using more of a continuation trust type structure. Okay? So in that case, the business ownership goes into a trust, and those non-farm heirs are the beneficiary. And it kind of works actually in a very similar way. The business keeps humming along. They don't have to pay anything out to those other siblings as long as the business is going. But if the business ceases to operate, it triggers that trust to distribute that share back to those other siblings. Okay? And so this one, so good and bad, right? Now you've got a little bit more protection for those non-farm heirs because a trust has trustees, right? And what is a trustee's job? Their job is to make sure that those assets are protected and taken care of. So you've added a little bit of protection to those heirs. Now in doing that though, if somebody's watching out for the value of those assets, what does it mean for the people that are operating the farm? It means now you've got another partner in there who's you might have to consult with on certain things. It also requires a little more intensive income tax management. But now let's go back and say, no, we want them to get a benefit during the lifetime of the business as well. Because this farm could go on for generations and generations, and they could be long dead before the business liquidates. So they're never going to see any benefit from it if we just wait until liquidation. So maybe we want them to get some value during the lifetime of the business. Okay? And in that case, we have to ask, do you want that to be a guaranteed amount, or do we want it to be subject to the profitability of the business? And they say, okay, we want it to be guaranteed. Set amount, they don't have to do a lot. We just get the same amount year over year. So in that case, we can look at land rents. And that one's pretty straightforward, right? Now we have the land owned by an entity usually that includes those off-farm siblings, and the farm pays rent to the land to use it. And as long as the taxes and anything else is paid for the land itself, the excess can go to those other siblings. So now they've gotten a small return. What they've also gotten is the appreciation in that land, right? So now they own the land. Not only are they getting a little bit of cash over time, but they're also getting the value growth in their portion of that land. Another method of getting them kind of a guaranteed return is instead, remember we said give them a small ownership interest in the business, and again we keep it limited. They don't get to make decisions about operating. They don't get to come in and say whether they can, what you can do with your cows or whether or not you can buy equipment. All they do is own a small piece, and you can just give them an interest payment on that, right? So they say, okay, make it simple. This business was worth $1 million, and you had 4 kids, 2 of them on the farm, 2 of them off, right? So if they had to buy their siblings out, they would have had to buy out $500,000 worth of value. But instead we say, nope, you don't have to buy out that 500. It can stay right here in the business, and we're going to keep using that capital. But because you left it in the business and we didn't have to buy you out, we'll just pay you interest for letting us keep using that money for that capital. And it's called a guaranteed payment for use of capital. Or we say, nope, we want them to benefit from the farm, but only if the farm is doing well, right? And in that case, we can give them more of a performance-based return. And they can still have that limited membership interest, but instead they get a distribution that's based on the profits. So does that kind of sound a little bit like stocks and bonds? Okay, that's basically what it is, right? You can say, those off-farm siblings, we don't want them managing the business. We don't want them telling the operators. And again, these might not even be your kids, but whoever's operating the business, we don't want them telling them what to do. But we do want to pass some wealth to them over time. So those are just a couple methods for doing that. Okay. I'm actually going to skip this one because I know Steve is going to get into this, and he speaks legal much better than I do. That the punchline is you need to be very careful about how the ownership of that land is structured. And if it is going to more than one person, any more than one person, I beg you to put it into an LLC of some sort, and do not try to leave it to them just jointly as individuals. And Steve will warn you about why. Getting into that land rents and the ownership structure, if it's in an LLC, that prior slide was the horror stories of what happens if it's not in an LLC. If it's in an LLC, there's just a lot more control and a lot more security for both sides. There's an operating agreement that dictates how the land itself is controlled, and then there's a lease agreement between the land holding entity and the operating entity. And boy, that solves a lot of problems. Or you can move the land into a trust. And as we talked about earlier, it might be a way to move it forward through multiple generations. And again, I'm going to leave most of this for Steve. We've tried not to overlap too much. But it is really important that if you put that land into that trust, it's a lot better to put it into an LLC first, a land holding LLC, and you put those LLC units in the trust instead of transferring land itself directly into a trust. Okay? It just gives you a lot more flexibility down the road. But putting the land into a trust, or the LLC units of a land holding entity into a trust, it allows you to basically operate exactly the same way. That cash goes from the operating entity, the farm itself, to the land holding entity in the trust, and those net proceeds after taxes and all that stuff is paid goes right back out to those heirs. It can go right out to those beneficiaries so they can continue to get that return for the rental on the land, but now the land is securely in a trust. And Steve's going to give you lots of good reasons why that's a good thing. Okay. And then to talk a little bit more about that potential return if you instead choose to give them some ownership in the business, even though they're not there, that limited ownership in the business. That guaranteed payment for use of capital, really think of it just like interest. The questions that you then have to ask when you're getting down into the nitty-gritty of that is, okay, so interest on what? Is it interest on the fair market value of what those assets were worth the day that you pass them on? Do we set that as the rate? And what interest rate do we give them, right? Do we use the market rate? Do we use like the lowest possible one, which is the AFR? Or do we look at the historical performance of the business and what kind of returns have come out of this business in the past? So these are all just, there's no right answer to these. These are just the questions that you want to ask as you're setting these things up. Okay. And then on the flip side, if we say, no, instead of guaranteed, we want to do something that's performance-based, well, now we've got more questions too. So we don't want to run into too much of cash flow issues, right? So if we say, well, we've given them a 10% interest or maybe even a 5% interest in the business for the last couple of years, daring, that would be great because they'd write you a check back. But in a very, very profitable year, right? So if you're in a very high profit year and you want to use that money to instead turn around and reinvest it in the business, and whether you're buying, other assets, instead you might have to distribute a portion of that to an outside person. Is that always ideal? So we want to make sure that there's rules set up around how that cash flow distribution will work. Okay. And then there's kind of a blend of those that I've seen where you use a tiered approach, right? So if you hit certain metrics, if your business does well, the outside owners get more. And if your business does not so well, they get something, but not a lot. So all of this hinges on profitability and cash flow. So we talk a lot during succession planning about like moving assets and transferring equity and blah, blah, blah. And all of this planning that we do is great. But it doesn't create new cash flow. So we have to make sure that whatever we've done, we're also allowing the business to continue to grow, and we have the profits and the cash flow in the business to facilitate this transfer, right? Because if we're moving this on to a next generation, we have to afford you some type of retirement, right? You have to live on something. We have to be able to attract the next generation. And we also have to replace the labor and management that you've been providing to the business. Okay, so this business has to grow in terms of profits and cash flow in order to facilitate this transition. And this comes back a little bit to what Chris talked about earlier. And I thank you, Chris. You did a great job of teeing this up to some of the really important and difficult conversations that come along with this. And one of those is understanding value. I think this is probably the biggest issue. We do a really good job of pointing fingers at the junior generation for being entitled and wanting things. But you got to look at both sides carefully, right? Because from the senior generation, usually I hear, well, this is what I need to live on. And the farm's going to support me because it's always supported me. Okay, but how much value is there actually in the farm? What are you actually entitled to? It's the asset value, right, that's there. And the value of the labor and management that you're providing. So we got to look at this business and say, does it have enough both cash flow and equity in here to support this? And then from the junior generation, they come in and they say, what do you say, Chris? This is what I got to have to live on. I need $84,000 a year. Okay, well, can the business afford $84,000 a year? I don't know, right? But you need to, instead you say, well, what would it cost to get these same assets or the use of these assets from someone else? So you say, well, I can't afford to buy the senior generation out because the farm can't afford it. So we can't pay that much. Well, then go buy it from somebody else, right? So how much would it cost them if they had to go elsewhere to get those same assets? And the best way to manage those conversations or to understand that value is that you manage those expectations from the beginning, okay? That you all understand, you have those conversations and you understand what is available. One of the things that I think is absolutely crucial, and I won't pick on you guys and raise your hands of whether you do it or not, but you really should be signing an annual meaning every year, certificate of value, okay, where you sit down with your business partners, all the owners, and you value everything, and you look at how the business has grown and draws and contributions of all the individuals. And if you can't agree, you may have to go even for an outside appraisal, but that everybody understands what the value of the business is, what the value of their share of the business is, and what their ability to get that value is, right? It's absolutely crucial. And the second piece is that you have signed legal documents that match your intent. And this is probably the thing that I ran into the most throughout my consulting career, was that you had legal documents and you had an idea of what you wanted them to say, and you got a legal document back from an attorney, and you said, probably, and you signed it and you put it in a drawer, and everything was fine until something happened. And you go to fall back on those documents and they don't say what you thought they said, okay? And worst case scenario is, Sarah, as Chris brought up, you're gone and you're not here to say, oh, no, that's not what I meant for that to say, right? So that these documents get reviewed every year along with the certificate of value, and you have this annual meeting where everybody sits down and you go through it and you make sure that it says exactly what you wanted it to say and that everyone understands what your intent was. We do have a few minutes for questions before I hand it off to Steve.
You're right, the transition is often very difficult between siblings when it's a generic, you each get half.
Yeah.
What, half of what?
Exactly. So half of what is that value? And again, half isn't usually the best answer because equal is not equitable, right? Different assets have different value because you have to work harder to get value out of them. Okay, Steve, I'll turn it over to you.
So I'm actually used to be a dairy farmer. That's where I started my career and became being an attorney is my second career. So I grew up on a 40-cow dairy in Cooperstown, graduated from Cornell, came back home, farmed for a number of years with my parents. Then I moved to a farm not far from where I grew up was hoping to work into a partnership with an individual who was in his probably 60s at the time. After about 6 months, I realized that was not going to work out. His mother was in probably her 80s. She still mated all the cows, paid all the bills, checkbook was in her house. And so I'm saying to myself as a 20-something-year-old, well, if she hasn't transitioned the farm over to her son yet, she probably isn't going to let it transition over to me. So I did my year commitment there, and then I moved on to Geneva area to Hemdale Farms, and I was a partner that was a large dairy vegetable operation, so I was a partner there for 9 years. And then I got the crazy idea to go to law school, and so here I am today. I actually still own a herd of cattle, continue to lease them back to a couple farms that I'm involved on, and that's my story. And then I was with a firm in Syracuse, and then in January of this year, I actually started my own law practice in Camillus. And so that's what I'm doing, but still doing the same thing, business and estate planning, working with predominantly farm clients. I can probably count my non-ag clients on about two hands. Picked up a few non-ag clients since I've been out in Camillus, but for the most part, I only work in agriculture. So a couple things, and Anna and I have a few slides that overlap a little bit, so some things I'll fly through pretty quickly, but the take home here is, this is really a team effort. Chris mentioned it in her talk. There's a lot of different parties that you need to get to the table in order to put together a successful plan. So, and every situation is different. It's probably your attorney, it's probably your accountant, it might be Farm Credit with their business consultants, it might be FarmNet, it might be Cooperative Extension, maybe it's your life insurance person, your financial planner. And it costs money to get all those people around the same table at the time. I realize that, and people kind of cringe a little bit, like I'm paying my attorney and my accountant. They always like to have the lenders there because they're free. But the attorneys, the accountants, the consultants, they all charge money. But everyone brings a little bit different expertise to the table, and I think it's really important to have that team assembled because you'll get a better plan when you're done, when you have input from everyone who has a little bit different perspective in your business. And oftentimes, as the attorneys, we're kind of the last ones to the table. I'd encourage you to get us there earlier rather than later, because sometimes we can help, if we're involved in discussions early on, it helps us when we put together agreements. And I think we do a better job of putting together the agreements because we can identify some issues early on that maybe don't get discussed. And then afterwards, the agreement's put together, and it's like, oh, well, what did you really mean by that? And, if we're kind of in the dark, it's hard to have a perspective. So it tends to go better the sooner we're there. And again, not all attorneys, not all accountants, not all advisors are the same. Agriculture is unique, and I think you want to work with people who understand agriculture, understand the issues. There's a lot of attorneys out there that say, oh, succession planning on the farm is easy. Split everything 4 ways among the kids and you're good to go. Well, yeah, that is easy, but you're probably, I can just about guarantee you that you will not be successful in transitioning the farm because there's not going to be enough cash flow for the 1 or 2 children who want to stay on the farm to buy out their siblings and continue the farm. And the plan needs to be flexible. You can't go to a book, pull a form out, and say, here's my succession plan. Every plan will be unique, and it needs to be tailored to your farm. And you need to look at it, because the plan that you put in place today, things are going to change. Chris mentioned that. You have to go back and keep looking at these plans. Anna suggested that you get together once a year and have an annual meeting. And that is really critical to look at the plan. Is it still on track? Do we need to tweak it? So there's lots of different ways we do planning, succession planning. There's estate planning, there's long-term care, there might be asset protection, whether it's LLCs or corporations or partnerships. We need to talk about matrimonial planning and prenups and postnups. And then we have the farm succession, transition planning. There's buy-sell agreements, there's leases, there's maybe housing agreements. One thing that people forget about is you're often living in a farmhouse. And so what happens if your spouse dies and it's a farmhouse? And, Chris mentioned that was something they did. They kept their house separate. Well, that can be really critical because that became her house. That was not part of the farm. It wasn't something where the spouse who's farming passes away and all of a sudden they need that house for the next manager or something like that. So, having a house away from the farm, separate from the farm, I think is a really critical component because it alleviates some of this additional stress. It's not only do you lose your spouse potentially in a death, but you're also not going to be kicked out of your house. And if you are in a farmhouse, then it's important to have agreements in place as to how long does that spouse or those kids or whomever get to stay in the house, because at some point the farm may need that house. At some point the farm may say, hey, we're tired of paying these expenses. It's one thing when, the husband or daughter was on the farm working. It's a different thing now when they're not there providing management anymore, or they're retired. I mean, that happens. Maybe you farm your whole life and then you retire, and it's like, well, we kind of need that house for the next generation to live in. So something to keep in mind. Anna touched on this out. There's just a lot of reasons why we should plan. And as Chris said, you need to get started. You need to do something. Any plan is better than no plan for sure. Anna covered those, so I'll skip right by those. So there's lots of different strategies that we use. We talk about different entities. Chris talked about it. Anna talked about it. It's complicated. I promise you that we really don't want to create more entities just because we want to create entities. I really don't enjoy having multiple LLCs and things like that. But there's a really good reason why we do it. Can you have too many? Yes, you probably can. But the main thing is there's reasons why we do it. So if it's being recommended, don't cringe, say, okay, my advisors have a reason for this, so let's go ahead and do it. Buy-sell agreements are critical. When I put together a new LLC, I tell clients the operating agreement, that really isn't all that important. I mean, your accountant worries about your operating agreement, your lender worries about your operating agreement, but I tell my farm clients, I go, if you're picking up your operating agreement every day or once a week to see how you're supposed to be making decisions, then I can guarantee you that your farm is not going very well at all. You will not be successful if you are going to a document to see how you're supposed to be running your farm. And that's basically what the operating agreement does. It covers the taxes, it covers who gets to make decisions and how those decisions are made. The buy-sell agreement, that is a document that says, how do we take this thing apart if something happens to someone? And my former business partner, Dale Heminger, always said, it's a lot easier to figure this out now when we're all forming the business, when we're all getting along, well, we all like each other, than it is at the end when we don't like each other because one of us is leaving. And, you can have a solid buy-sell agreement and you can have a party exit and have it go really seamlessly. And that's what happened when I left, Hemdale Farms and Castle Holsteins, is I got bought out, and I have a great relationship with all of them, obviously, because my cows were still there. And so, we had a document to go by. We didn't go by 100%, but we at least had a baseline, and it was a very smooth transition. You have to worry about estate and income taxes, not as much on the estate side anymore, but as Anna alluded to, there's a lot of income tax implications that need to be addressed. You may want to use trusts. Trust can be a dirty word, but I think they have their place. It depends on the situation. And then life insurance. You can have too much life insurance, that's for sure. You have to be careful. There aren't any life insurance people here, so Anna didn't pick on them much. I'll pick on just a little bit. I mean, there are some life insurance people who want to sell you life insurance. So just be careful of that. But it does have its place. It is a tool that you can use for succession planning. So, keep an open mind about that. So estate taxes, like I said, we really don't need to talk about them much anymore. Do we care? Perhaps, maybe on the New York side a little bit. On the federal side, really not at all. So why do I say that? Federal estate taxes, the exemptions are so high, at least for right now. I mean, if we get a new president, a new Congress, this could change at any point in time. They always pass the laws and they say this is permanent, and then a new administration comes in and it gets reworked. But as of right now, we have a $10 million base exemption that's indexed for inflation through 2025. So that's where we are, at least through 2025, until the laws change. So today, everyone in this room has $11.4 million exemption. Next year, it's going to 11.58 because, again, it's indexed for inflation. So basically, a husband and wife couple today can protect $22.8 million worth of assets. So it's a big number. Even my really large farms, with multiple owners, were easily under that number. So on the federal side, estate taxes, is really not that big of an issue. The exemption is what we call portable. That just means that it can be left between spouses. So if a husband passes away and we don't use any of his exemption, that's okay, because it can be left to the surviving spouse, and then upon her death, it would be available for the kids to use. Now, it is important. You have to file some paperwork with the IRS if you want to do that, so it doesn't happen automatically. But if you file the appropriate paperwork with the IRS, you can transfer that unused exemption. And you might use part of it, and then you can transfer the balance. So it's not an all or nothing. You just have to file the papers. And the top rate's 40%. And then in 2026, unless it happens sooner, we're reverting back down to a $5 million base exemption that's indexed for inflation. So, I'm guessing Off the top of my head, we'd probably be right around 6.4 million-ish right now if we were under the old regime of the 5 million base. So again, a decent number, and that's per individual. So husband and wife are going to be up over 12 million. So again, with a medium size or even a large farm, you're probably okay. New York's a little bit different, and of course New York has to be complicated because we can't keep anything simple. So right now we have a $5.74 million exemption per person. So basically husband and wife can protect $11.48 million worth of assets. It is indexed for inflation. So in 2020 the new number is going to be 5.85. It is not portable. So this is one of the difference between federal and New York, is in New York you either use your exemption or you lose it. So we might, and this is critical, this is where you have to be conscious of estate planning in New York. You could have a family, or I could have a family with, $6 million worth of assets, okay? So they're well under an exemption between husband and wife if they do their planning right. But if they don't do their planning right, and the husband dies first and we don't use any of his exemption, well, now when the wife dies, she has $6 million worth of assets and the kids only have a $5.74 million exemption, and now we just triggered a New York estate tax. With just a little bit of planning, we could totally eliminate any estate tax at all. But we didn't use the husband's exemption, we lost it, and now the wife and the family do not have enough exemption left over to protect their assets. Spouses, both in New York and federal, can leave unlimited assets to each other. That's fine. That will not trigger any kind of estate tax. It doesn't trigger any kind of gifting. Both New York State and the IRS are not worried about gifts between spouses because they say, well, when the second spouse dies, that's when we'll cash in and collect our taxes. New York does not have a gift tax, but you can end up paying a gift tax at death. It all depends, and the software is really complicated, so I know enough about this to be dangerous. But the take-home message is, until you actually plug the numbers into the software that calculates an estate tax, a value of a gift that you made during your lifetime may get brought back in and be calculated into whether you have an estate tax that's due or not. And that's about all I'm going to say. It's complicated. No one really understands it until you plug the numbers in the software, and it just depends on when the gift was made and how much and things like that. So it's a little bit of a trap to be worried about. The take home is, if you do your planning between husband and wife, you have a really big exemption. You just have to make sure you use it appropriately, and then you'll be okay. And the rate in New York tops out at 16%. So the good news is that if you have a New York estate tax, it's not a crazy amount that you'll pay because it's only 16%. And that's the top bracket, so there's lower brackets, obviously. Now, this is where you thought New York was complicated. This is where it really gets complicated. So we have what we, in the professionals, the accountants, and the attorneys, we call it a cliff. And so it's the estate tax cliff. And the idea is, I just told you that you have a large exemption. Well, the problem is, if you're 105% over that exemption, you lose it, and you go back to the $1 million that we used to have. You're like, how can I lose my exemption? Well, that's how the law is written. So they never, when Albany updated the estate tax law, they didn't get rid of the old tables. And they didn't really change the verbiage. They just said, hey, if you're 105% over, we're going to pretend that instead of having a $5.74 million exemption, you only have a $1 million exemption. And this catches a lot of people off guard. So they're like, okay, I have a $6.4 million estate. To the common sense, right? You're saying I have 6.74, I have a $5.74 million exemption, I'm $1 million over, right? Simple math. No big deal. The tax should not be that high on $1 million. The answer is wrong. It's as though you are actually 5.74 million over, because you only have $1 million exemption the way the tax gets calculated. So a lot of people get caught off guard.
What's the tax rate for that?
You're still at the 16%, but at the top rate. So, I used to do the calculation, but it's a big number on 5.74 million, even at 16%, knowing that some of it's at a lower bracket. But so you just have to be really careful about that. Do not go more than 105% over your exemption. Otherwise, you're going to trigger this and pay a lot of tax. And again, this is where we get into planning between spouses. Lots of times, husband and wife just need to move assets between each other in order to maximize each other's exemption. And then when you die, don't leave everything to your wife or leave everything to your husband, because that wipes out the whole plan. So you've got to have a will that works, and you have to have the assets owned correctly. And if you do those two things, then you'll be fine. So we can plan around it. We just have to do the planning. So what do you need? I said it, the question came up earlier. Do you need a will? Well, yes, there is always a will, like I said. It's just a question of whether it's a will that you and your attorney wrote, or is it one that New York State writes for you? Because there is one out there. There's a law. It's called the Laws of Intestacy. And it says when you die, if you don't have a will, this is where your stuff goes. And so, again, you may not like what New York has decided for you. Probably won't. So that's the take home is go see an attorney, get a will. Had a farm client. They came to me after the fact. The wife had passed away. There was 3 kids on the farm. Husband was still alive. And I was brought in to help them with some planning, because it was a mess. Because here's what happened. The wife died, did not have a will. Because there were kids, some of the assets went to the kids and the husband. Well, that was okay, because the kids were adults, and the kids were all on the farm. So it wasn't the best plan, but it was going to work. One of the daughters was so distraught over her mother's death that she committed suicide. And so we now have a deceased daughter. Before the estate could be settled, the deceased daughter had young children. The deceased daughter also did not have a will. So now we have grandchildren who inherited part of the farm. And that really complicated things, because the grandchildren were not old enough to make decisions by themselves. They were 7 or 8 years old. So the courts say we have to appoint an attorney to look after the best interests of the grandkids. Well, the problem is this attorney, and any attorney's got to look after the best interests of the grandkids. He or she really doesn't care about the farm. He or she cares about making sure the grandkids get their fair share. And so what could have been, 2 very simple wills, not a lot of dollars, has turned into a huge expense for the family as they try to work through what's the farm valued, how are we buying out this daughter's share, how are we getting the money down to the grandkids, are they getting a fair deal? Fortunately, the husband is of the deceased daughter. He's kind of on board with the farm plan. So I think they're working through things. I haven't been able to help them until they get through all these hurdles. But you talk about expense and aggravation and stress just because people didn't have wills. And I was at the meeting, and I said to the husband, I'm like, well, do you have a will? He's like, yes, I have a will. And actually FarmNet was involved. And so the 2 of us said to him, well, why did you have a will and your wife didn't have a will? And do you know what his answer was? He goes, because I was going to die first. So I needed the will, but she didn't need the will. So, and then if you're young, who will raise your children? Or if you have young kids, who will raise your kids? Who's going to pay your bills? Who's going to pull the plug? These are all kind of life, with who's got to pay your bills and who's going to pull the plug. Those are life planning decisions, not the will. So like we talked about, I mentioned this earlier, so there is a laws of intestacy. If you die without a will, you're married with kids, Surviving spouse gets $50,000 plus 50% of the estate. So the kids take 50% basically of the estate. That may or may not be the right result. If you have minor children, then they obviously don't get the money because they're minors, but the day they turn 18, they can walk into a court and demand that they get their inheritance. Go ahead, Chris.
So the way that some farms, I mean, in Wisconsin, they're losing 2 dairies a week to bankruptcy or whatever. So where does this 50,000 come from?
And that could be, assets have to get sold, or it can be the value. So it doesn't have to be $50,000 worth of cash. It can be the first $50,000 worth of value. But that, that raises a whole issue. Where do we get the liquidity from? Which may mean selling assets and putting the farm out of business, or at least jeopardizing the viability of the farm to come up with the cash to do this.
Are life insurance proceeds included with this?
So life insurance is it's a non-probate asset. Now you're asking me to really know the laws of intestacy. I think it counts as what we call a probate substitute, so I believe life insurance does get factored into that, but don't hold me to that without actually looking at the law. So you're getting into estate administration, which is an area that I don't do as much of as estate planning.
The life insurance policy as the wife is first beneficiary, that means she gets all of it, but this adds a whole different layer of stuff to that.
Yes. So people always think, I'm married, I don't need a will. And the answer is, well, if you have no kids, then yes, that plan works. Because if you have no children, New York's law says everything goes to your spouse if you don't have a will. But as soon as you throw kids into the equation, now you're under this regime, which again is probably not the desired outcome for a lot of different reasons. So what other estate planning documents do I recommend? Obviously wills, healthcare proxies, financial powers of attorney, the living will. For my farm clients, I can call it the down cow document. I'll explain to that in a few minutes why I call it that. And then trusts. So trusts may or may not be part of your plan. So the financial power of attorney, durable power of attorney, this is just a document that allows someone to handle your financial affairs if you can't do it for yourself. The law changed about 10 years ago now. I actually love the old power of attorney. Erica, who hasn't been practicing that law, doesn't know how good the old one was, because it was like a page and a half, and you signed it one place and you notarized it one place and you were done. Well, New York decided that we can improve this, and so now we have a 13-page document, which they call the New York Statutory Short Form. So all attorneys, we use the New York State Statutory Short Form. I honestly don't know what the long form is because we only use the short form. But it's 13 pages. It gets signed in a couple different places. It gets notarized in a couple places. So what used to take me about 2 minutes to get through now takes about 10 or 15 minutes, because you have to sign an initial in, probably 10 places. The old powers of attorney are still good. The problem is that banks in general don't like powers of attorney, unless it's their own. They love their own power of attorney. They don't like they don't like New York State's official form. They just like their own. They certainly don't like the ones from pre-2009 because they don't know what they look like. And so if you have an old one, it is still good. The problem is it may not allow you to do some gifting and some other planning that we like to do today, because it doesn't have what we call the statutory gift rider as part of it. So I recommend to clients that even if they have an old one, even if they have the right people appointed, you should update it, just because that's the form that everyone's used to seeing today, and it makes it easier when you go into a bank to use it. They're still going to give you a hard time at the bank, but they'll give you less of a hard time. We've actually had clients who have tried to use the old ones. There's a law on the books that says the old one is still good, and sometimes it takes faxing that law to the bank to convince them that they can use the old one. Sometimes it also takes faxing them the law that says the New York power of attorney is actually good in New York. We do not have to use the bank's power of attorney, because again, some of the big banks have their own form and they think that's the only form. You get to choose whether you want 1 or 2 people acting. They can act separately, they can act jointly. It's just a conversation that you need to have as to who's going to make your decisions and whether they work together or if they work separately. The healthcare proxy, this allows someone to make medical decisions on your behalf if you're unable to do it for yourself. It needs to have the HIPAA privacy language in there. So again, if you have an old healthcare proxy, probably isn't any good, because if it doesn't have the privacy language, hospitals aren't going to recognize it. With this one, you can only appoint 1 person to act at a time. You can name multiple people in the document, but only 1 person can be acting, and that's because hospitals do not want a fight in the emergency room, so they want to go to one of your children and say, what are we going to do? Hopefully the family as a whole would make a decision, but ultimately there's just 1 person who's going to go to the doctor. Something that people lose track of, if you have college-age children, you need to get a power of attorney for them if they're over 18, because once they're 18, they're adults. If you have a son or daughter at college and they go, to the hospital and you want to find out whether they have strep throat or anything else, you technically cannot access any of their medical records without a healthcare proxy. So we do a lot of these for people who have college-age kids, just so that if they're away from home, mom and dad can make medical decisions or get medical information if necessary. And then we have the living will. This is what I call my down cow document. And so if you're a dairy farmer, you can appreciate this. This is where you are at that point in your life where you're not coming back. 2 doctors have examined you and have determined that there's no hope of recovery. And so you have to indicate whether you want food and water continued or discontinued. So again, New York says even though you've given someone a power of attorney to make medical decisions, they want a statement from you as to whether we continue or discontinue food or water. I had, for my farm clients, you can appreciate this, I was doing a meeting where I was explaining this, and the farmer said, well, why don't you just get out the 22? I said, well, we can't do that either, but. So trusts, there's a lot of trusts. There's revocable, there's irrevocable. It depends on the situation. Trusts tend to have maybe a dirty word. They can work really well. It just depends on what you're trying to do. The take-home message, revocable trusts can be changed at any point in time. Irrevocable are, set in concrete. They are what they are. Let's see. Income only. This I think, works great for farmland. I do a lot of these. It allows you to continue to receive the income. So if the younger generation is renting the farm from you, you as a senior generation would get the income. We protect the asset from a nursing home after 5 years. You do have to give up control. So that's what my clients always struggle with, is they don't want to give up control. But it is a great tool. I do a lot of these. You get a step up in basis, and which is for tax benefits upon your death. So a lot of benefits there. Let's see. A couple things, and I'll go getting tight on time here a little bit. Does the business die upon your death? So we're talking about succession planning. Well, if you're going to have a succession plan, you have to have a business that can continue if you die before you complete the succession plan. So if you're a sole proprietor, there's nothing to transition, because upon your death, that sole proprietorship dies with you. That tax ID number is extinguished. That business is over. You have to start up a whole new business. If you're a partnership, it may or may not continue upon the death of a partner. You have to be careful here. A lot of old partnerships have language in their partnership agreement that says the partnership terminates upon the death of a partner. I had a client in northern New York where 3 brothers had a partnership, And actually, it was one of the farm credit consultants picked it up and then brought me in. That's how I got involved. The partnership agreement said, upon the death of a partner, this partnership is over. Well, one of the partners had stage 4 cancer, did not have that long to live. We really quickly did an amendment to eliminate that requirement that the partnership dies upon the death of a partner and said it shall continue. We then did an LLC, but this was a quick Band-Aid because the last thing that anyone wanted was that partnership to terminate because one of the partners died. If you're an LLC or a corporation, then those businesses continue on beyond the death of any of the partners. Then we always have to talk about, the business heirs and the non-business heirs, and Anna brought it up, and, is it equal, is it fair, fair is not equal, equal is not fair, blah, blah, blah. You've heard it a million times. It's all true. So you have to figure out how to do that. And then, buy-sell agreements and leases are a critical part of that plan, and maybe trusts as well. So Anna touched on this. I'll break it down. When I do a meeting with clients, I say you have 3 buckets of assets. You have the operating assets, you have the personal assets, and you have the farmland. And I really think it's almost that simple when you start talking about how are you going to pass assets to each generation. If you put them into those 3 categories, then you can begin thinking about exactly what you want to have happen. And Anna talked about, what are the operating assets. I won't go over that. My only comment is, they might be high value, but you can't use the cows to go on vacation. And, cash can buy you a new house, new car, nice vacation. The operating assets, they don't do that. And that's the benefit of the personal bucket. And then the farmland bucket. And I like to use a farmland bucket as that's kind of the equalizer, because you can get pretty creative as to what you do with the farmland, particularly if you put it into a trust. And so you can provide benefits to the farming children, and you can provide benefits to non-farming children. And Anna kind of alluded to that. And with leases and LLCs, you can accomplish what you want to and use that to kind of equalize your estate, or at least make it more equal. There's lots of different tools that we use for transfer. Kind of talk about this, how are you farming? That comes back to whether we can even begin to do succession plan if you're not farming correctly. So land ownership, I do want to spend some time on this. There's 3 ways in New York State as to how you own land. You can own it as tenants in common. You can own it as joint tenancy with right of survivorship. And then you can own it as tenancy by the entirety, which is husband and wife. The only way you know how your land is owned is to go look at your deed. That is the only way. You have to look at the deed and see what the magic words are on there. Do not look at your tax bill. Just because both your names are on the tax bill does not mean you're joint owners. Believe it or not, the county or the town makes mistakes when they do tax bills, and so they may not have the correct owners identified on there. If you bought land when you were married, the default in New York is you own it as tenancy by the entirety. So that is the default. So unless you tell your attorney, we do not want to own it jointly as husband and wife. If the deed says nothing, that's the default. You were married at the time you bought it as joint tenants. You can change the ownership. It's easy enough to do, but you have to prepare a new deed. That's the only way that you can change ownership. So tenancy in common, tenants in common, everyone owns an undivided undivided interest in the land. So if Anna and I own land as tenants in common, I own 50% of every square inch. She owns 50%. Upon either one of our deaths, our will is going to control where that land goes. So if Anna dies and she leaves everything to her spouse or her child, I now have a new partner on the real estate. And that's how that land is transferred. It's transferred under a will. And I can do nothing about that. It happens. It's whatever her will says. Joint tenancy is, right of survivorship. It passes automatically. So if Anna and I, same piece of land, we own it as joint tenants with right of survivorship, the last one living gets it all. So Anna can have a will, and she thinks, I'm leaving this to my husband, Marcus is going to get this farmland, I don't want Steve to have it. Doesn't matter what her will says, I am automatically going to get her interest in that land, and now I own 100% of it. So last one living gets it all. This comes up a lot on farms where, brothers own land as joint tenants with right of survivorship, and the spouses are really shocked when they thought that when their husband died that they were going to get bought out of the real estate. Well, sorry, they're not getting bought out because there's nothing to buy out. It automatically went to the surviving business partners. I see some people do this with, parents and kids thinking this is an easy way to pass the land. We'll make it joint tenants. Mom and dad will own it jointly with their son or daughter. Mom and dad are going to die first, so son will end up with it or daughter will end up with it. Well, most likely, but we don't know which order people are going to die, so that plan doesn't always work either. And then tenancy by the entirety, that's a joint tenancy. It's just that it's between husband and wife. So the only one that works for is you have to be married, and then it automatically, again, the will could say if Anna owns property with Marcus, they bought together, her will could leave it to me. Doesn't matter what her will says. He's going to get it automatically because it's joint tenants. Okay, so, and Anna touched on some of this. I think LLCs are a great tool for succession planning. They give you incredible flexibility. You can change the way that it's managed, how it's owned. It's easy to bring people in. We can have veto power in the way that we do voting. I usually make mine manager managed. The managers are probably the owners, but this gives you more flexibility because a person can be a manager but not a member, or more often than not, they're a member but not necessarily a manager. This works great in succession planning. In the beginning, the senior generation wants to have a say in what's going on. So they're managers. Maybe the kids aren't even managers yet. Then you transition to where senior generation and kids are both managers. And then kind of the final step is the kids are the managers and the senior generation are just the members on the side. You can change the way the voting is, so it can be one vote per person. You can do a weighted vote based on ownership. Some decisions might be made by managers, some might be made by members. You can have simple majority, which is 50, basically 51%, 50.1% would make it. You can have supermajority. Supermajority can be anything you want. It can be 66%, it can be 75%. You decide what is supermajority. I do a lot of mine where there's a tiered approach. So there's some decisions that are, simple majority, 51% decides. There are others where we feel, maybe 70% of the business owners need to be in agreement. And then there's those major decisions where before you do it, probably everyone needs to agree. And so you can set up your operating agreement to do that. In your handout is, in your packet there is an example of how this decision making would work. I kind of skipped through this quickly, but this was a farm that I worked with. Dad was retired, but we had, two brothers who were the second generation. The one brother had two sons who were on the farm, so now we have a third generation. The other brother had two daughters who were younger. They may or may not come back to the farm. So we set this up where we had 4 managers and 4 members. And, but again, we had some manager level decisions that everyone was equal, but we have member level decisions where, the parents, the senior generation, get to decide. I just met with a client yesterday. The mother or grandmother, depending on, there's now 3 generations, so she's grandma. She's in her 80s. She's still very much running that business. And so I did an operating agreement where there was simple majority decisions, 51%, But my operating agreement says Marion, being the grandma, has to vote with a simple majority or you guys don't get to do it. And so you can build things in like that. So even though she might someday be a minority owner, she still wants control. And so the operating agreement says, hey, there are decisions that if mom or grandma don't agree with, even though we outvote her, we cannot do it because she has veto power. And that's where you can get really creative, just trying to accomplish the goals that people want. Buy sells, Anna touched on it a little bit. Usually there's 3 or 4 events that trigger it. It's always death, disability, termination, or retirement. So you have to identify what causes you to get bought out of the business. Are you going to do discounts? How are you going to determine your buyout price? And then how are you going to pay for it? Those are kind of the bare minimum things that you want in a buy-sell agreement. Lots of reasons for discounts. I think certainly a 10% discount is appropriate in all cases. And the reason for that is if you were to liquidate your business tomorrow, you're not going to get full value. You have to pay me, you have to pay the consultants, you have to pay the accountant, you have to pay sales commissions. They all add up expenses. So if you wouldn't get full value during lifetime, should you get full value at death or at retirement or something like that? Because what happens if you do full value is, one person if you have 4 business partners, and so one retires, so you buy him out at full value, so the other 3 paid full ticket. Now you're down to 3. Another one retires, you buy him out at full value. Now we're down to 2. She retires. Well, the last one living, or last one in the business, paid full value for everything, and now they go to liquidate, and they only get 90%. So that really doesn't seem fair. So that's why I do that discount. And it can be anything you want. It can be 10%, it can be 20%. You guys make up the number depending on how you want to transition the business. In family situations, we often use a bigger discount. In non-family, it's a smaller discount just because you're not as interested maybe in seeing the farm, getting the farm all the way over there at less than full value. So you take a smaller discount. And you can do different discounts depending on the event. So it might be a large discount. I have farms where if someone leaves, it's a very large discount, whereas if they retire, it's a smaller discount. So it depends. Did you farm your whole life and now you're retiring? Well, maybe you only take a 10% haircut. If you're 35 and you're going to law school, maybe you take a really big discount. How are we going to determine the purchase price? With my farms, I think it's relatively easy. Ideally, you have a certificate of value. Anna alluded to this. Every year you sit down and you determine what your business is worth, and then you sign off on it. If that doesn't work, you might do an appraisal. Again, with farms, that works pretty well. You have hard assets that are easy to appraise, easy to put a value on. If you have a non-farm business, then oftentimes we use some multiple of earnings. That'd be like a service business or a restaurant, something like that that's not quite as easy to value. Whatever you do, when you set a price, you don't want the price to be set forever because that's not fair to people. The farm grows, you add more cows, you buy more land, it's worth more, you pay down debt. So you need a mechanism for updating that or saying it's only good for a period of time. Usually I'll use like 18 months. Ideally, you do it once a year. No one ever does it once a year. You're busy. 12 months turns into 13 or 14 months. Well, hopefully if we do 18 months, within that 18-month period, we'll get back together and we'll do a new value. And I tell clients you can always agree to something else. If you can't agree, that's when you come back to the document. It's always easy to go up. It's just about impossible to go down, especially if someone dies and you're negotiating with non-family, non-farming heirs. Chances to get them to take less money, I think, are pretty remote. If you wanted to offer them more, they'll probably sign up for that and you'll get an agreement pretty easily. Payment terms, how are you going to pay for this? Is there life insurance that's going to be a down payment? Is there a promissory note? How many years is the note going to be payable over? What's your interest rate going to be? One thing to be careful of with notes, if you're using the farm assets as security to secure that note, is what about your primary lender? And your primary lender, Farm Credit, Community Bank, it doesn't matter what bank I choose, they always want to be first. So they're not going to want to have a private mortgage out there. So it's important to have in the documents that say, okay, even if we do a mortgage, that mortgage is going to be second to our primary lender. Otherwise, you can really handcuff the farm's ability to go borrow and expand. Yes, it makes you a little bit more unsecure, but again, you have to decide, do I want to make sure the farm is transitioning, or what's our end game? Vesting schedules, I've got a couple slides on this. Farm housing, I talked about that in the beginning, that's critical. Prenups, I do a lot of prenuptial agreements. I think that's important to have in the document. I tell people, let me put in a prenup requirement. So, if your son or daughter is coming back to the business, I'll add a paragraph that says if they get married, they have to have a prenup. That way, you can blame me. I can be the bad guy. I get thrown under the bus all day long, doesn't bother me. But you can say, honey, it's not my fault. It's that attorney in Syracuse or Camillus. He put it in there, and so now we have to do it. Vesting, there's lots of types of vesting. I'm probably pretty much out of time. The main thing here is, it works great for the junior generation. The concept is they come back to the farm, you start transferring assets to them, but they don't own them for a period of time. And cliff vesting is the idea where, it might be the first 5 years. If they leave within 5 years, they walk away with nothing. After 5 years, they begin to become vested in that interest. And so now if you do have to buy them out, you have to start paying more. I tell parents, the last thing you want to do is give your son or daughter a whole bunch of equity and then buy it back in 3 years because they decided farming wasn't for them. And if you don't have vesting, that's exactly what you're going to do. And you're not going to be happy with that. So if you bring kids in and you're going to do gifting, then make sure you do some form of vesting to protect you in case it doesn't work out. Step vesting, the concept is you vest over a period of time at a percentage. If it's 10 years, it might be 10% a year or whatever, 5 years. But it's, again, different ways to protect yourself. Sometimes we do a combination where, just like it says, for the first couple years, it might be 0% vested, and then after that, they begin to step vest. This is really important, permit transferees. This just means, can you leave your interest to someone and not trigger a buyout? So if your agreement allows for a permit transferee, it means that you, as a business partner, could end up with someone that you didn't expect to be a business partner. So picking on Anna, we have a business, we're 50-50. We have a buy-sell agreement. Says that, permitted transferee is any lineal descendant. So Anna has a daughter. She dies. She leaves her interest in the business to her daughter. Guess what? I have a new business partner. I think your daughter is worthless. I don't want to be in business with her. I'm stuck with her, because we had this provision in there that said she could leave it to her daughter. Now, you can build in language that says, hey, if her daughter's in the business and in the management capacity, great, she can inherit it. And I might say, yeah, that's wonderful. Anna's daughter, she's here every day. She's managing the business. I'm fine. I don't want to buy out Anna's interest. I'm happy to have a new business partner. So be careful of this, because it's a dangerous provision if it's not used correctly. Other documents, Anna talked about leases. They're critical. Retirement, life insurance, long-term care insurance, prenups, and that's pretty much it. Again, I just encourage you to go talk to people. There's a lot of resources out there. You're lucky Erica Hooker's here today. She's a young attorney too that's gotten started, so she's a great person to talk to. I'm here. You can talk to either one of us, and if you want the right answer, go see her. If you want my answer, come see me.